podcast is provided for informational and educational purposes only and should not be construed as legal advice. Because every situation is unique, you should consult with a qualified legal professional for advice specific to your circumstances. If you need legal guidance, please reach out to an accredited attorney or contact us to schedule a consultation. Hello, and welcome back to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. Today, we are going to be talking about a very common issue that we deal with in VA claims, and that is the presumption of soundness. You may have heard of presumptions before. We'll probably do more episodes on presumptions, on different kinds of presumptions. But what a presumption is in VA law is something that you don't have to prove. If you meet certain requirements or certain metrics or facts are established, you don't have to prove the next piece of it. So the presumption of soundness is when you're dealing with VA disability law, you have to show that something was caused, that you have a current disability, that something happened in service and that was caused by the service. So presumption of soundness goes to whether that was a pre-existing condition, whether you had something before you entered service. So, if you entered service with severe asthma, if you had severe symptoms of asthma, they probably wouldn't let you pass the MEPS physical. You wouldn't be able to join the service. But there are some conditions that you might get a waiver for and join the service. And then we're looking at whether it was aggravated during service or whatnot. But the question comes up a lot, especially for people who didn't complain about symptoms a whole lot during service. Was this condition really started during service, or did it predate service? Was it pre-existing? So we're going to dig into that presumption of soundness and answer some questions. And if you have more questions at the end of the episode, I hope you pop them in the comments section, because we love hearing from the audience. So we're going to go over what the presumption of soundness is, when it applies, when it does not apply, why VA sometimes gets it wrong, sometimes a lot of times gets this one wrong, and what evidence matters. So what is the presumption of soundness? The presumption of soundness is the general rule that when someone enters service, you are presumed sound. You are presumed that you are fit for service, that you don't have any disabilities at the time you enter service. There are a couple exceptions to that rule. One exception is things that are noted on your entrance exam. And the other is if VA can prove with clear evidence that it was not started in service, it actually did predate service. So VA can overcome the presumption, but they have the burden of proof. So the entrance exam matters because that's the legal baseline. So what is noted on your entrance exam is really, really important. And VA gets this part wrong a lot. But basically, just because you told your examiner during the entrance exam that you had a history of something doesn't necessarily mean that that you had it noted as a current condition at the time of entrance. So a lot of times people will have childhood asthma. It kind of clears up when you hit puberty. You play high school sports, no problem. It could be noted on your entrance exam that you had a history of it, but if you don't have a current diagnosis of it on your entrance exam, then that's not necessarily evidence of a pre-existing condition. And that's part of the thing that we'll get involved with sometimes, is showing where VA gets that part wrong. But it really has to be a current disability noted on your entrance exam. So if your entrance exam checks the box, says normal feet, you've got normal feet. If they say you have a history of painful feet, it's one thing, did you bump your feet playing soccer in the backyard without shoes on and it's healed up? It's another thing if they actually note on your exam that you have flat feet or pes planus. And that's when we can kind of get into. And in the next episode, we are going to be talking about aggravation. So right now I want to focus on presumption of soundness and establishing whether something pre-existed service or not. So what does it mean to have it be noted on your entrance exam? It's not enough to just say you have a family history of something. It's not enough to show that you had a childhood injury. Old medical records alone are not necessarily enough to show that you had a current condition at the time of entry to service. Your statement that you once hurt yourself or that you used to have symptoms, probably not enough to show a pre-existing condition. And speculation This is one I think a lot of VA examiners like to add in. Speculation is not enough. This seems like something the person would have had for a long time, so I doubt that it started during service. That is not an adequate VA medical exam. Unfortunately, we do see that sometimes, and that's something that we'll come in and fight because that's incorrect. In order for VA to show that you had a pre-existing condition, it really has to be noted by the medical examiner at the time of service, at the time that you entered service. In order for VA to overcome the presumption of soundness, so once the presumption of soundness is established, VA has to overcome that presumption. So VA now has the burden to prove that it wasn't incurred or caused by service. So their burden is clearly and unmistakably, they have to prove with evidence that it's something clearly and unmistakably existed before service. So that's why a few statements that you had some pain earlier, that you've had symptoms in the past, are not enough for VA to say this clearly and unmistakably was present at the time that you entered service. And they also have to show that the condition was clearly and unmistakably not aggravated during service. And that's the topic of the next episode, is aggravation. The other kind of caveat here is if something is a congenital defect or congenital deformity. So if you have a hole in your heart and that wasn't discovered until you got into service, but once you're in service, then that's a congenital issue. That's something you were born with. That is something that VA doesn't have to grant service connection for. And again, there can be some aggravation and there's some nuance between what a congenital deformity is and what a congenital disease is. So that can get kind of nuanced. But typically, if something began during service and it wasn't noted on your entrance exam, you have the presumption of soundness, meaning that there's pretty clear evidence that, especially if it's noted during your service treatment records or there's evidence that something began during service, you're already in a better position because VA has to prove that it was not pre-existing service. So some of the common errors that VA makes, like I said, a lot of times the VA examiners don't fully understand this presumption of soundness. And so when they're giving opinions, they'll write things like, well, this clearly predated service. If they're not giving a solid rationale about why something predated service, or if they're not referencing medical records or clear evidence that something predated service, I mean, theoretically, I guess they could show that based on the trajectory of the progression of the disease, that you would expect that it would have started sooner. Is that clear evidence that predated service? Probably not. They would have to really show a lot of evidence that to overcome that presumption of soundness. But sometimes we'll get clinicians that just say, well, yeah, this is the type of condition that typically begins during childhood. So I think it's less likely than not that it began during service. That's not the standard. So I think VA gets that wrong a lot. It's a legal standard, and there has to be clear evidence that something pre-existed service. So the examiner saying that they think it pre-existed service is not enough. Having the types of conditions. We get this a lot with mental health. We do. We see it a lot with mental health claims because mental health can be kind of a fluid thing. What caused you to be the way you are? What caused you to have your anxiety or your depression or, your traumatic responses? It can be a cumulative thing. So you might have had some issues in childhood and you were fine. And then when you entered service, it brought stuff up from your childhood. It's very rarely that it's one thing that defines our entire personhood or our entire response to situations. And the military generally does recruit they recruit from all over, but there are concerted efforts for recruiting from impoverished areas, inner city. I definitely have heard people say, hey, you can enlist and get out of jail time or community service. The judges will give you that option. You join the military or go to jail. So there are people who've come from family abuse, inner city violence, neglect, loss of family members in your childhood. But if you weren't diagnosed with a mental health disability at the time that you entered service, and then you join service, and it's just, no matter what you're doing, there's a lot of stresses around being enlisted or being a commissioned officer, your PCSs, deployments, the having to live nonstop with your coworkers, not getting that break away from the people who you're dealing with day to day. Just the basic structure of the military can add stresses to people. And if you're coming in with not pre-existing, pre-diagnosed conditions, but maybe predisposed to, more susceptible to those stressors. That's not a pre-existing condition. If it began during service, you can still get service connection for that. We've had cases recently where clients had very, very severe trauma during childhood, nothing treated, nothing noted at the entrance exam. And then they had what I would consider more mild stressors during service, but those stressors were just enough. It was the straw that broke the camel's back. That was the piece that really put these people into kind of a spiral and triggered severe, long-lasting PTSD. And if you just look at the one trauma in service, I think a lot of clinicians would say, well, that's probably not enough to cause the level of disability that this person is experiencing. But they need to look at the issue from the lens of, was it a pre-existing condition? Were they diagnosed? Did it start before service? And the answer in this one case I'm thinking of right now, and we've seen it over it repeated over and over. No, VA cannot show that this condition pre-existed service. So even if there was childhood stuff that might have played into it and might have made this person more susceptible to developing a disability in service, that's VA's burden. It's kind of the military. If you break it, you buy it. So, if they get somebody in who's more fragile and then they break that person, I'm using terms kind of loosely, but VA has to pay disability benefits for that. So it doesn't matter if there are things prior to service that make you more susceptible to it. I mentioned briefly the congenital disease, congenital defects. So just because you were predisposed to something, you have a genetic predisposition, your parents developed arthritis or heart disease or something like that. You have a long family history of pancreatic cancer. Whatever it is, if it began in service, it's still going to, unless it's a congenital defect, like a hole in the heart or something that was already there and just not detected, just because you were predisposed to something, when it develops in service or because of something in service, VA can't show that it was pre-existing. So they're not looking at, well, you had all these potential things before service. They're looking at what in service caused the condition, even if you came in more susceptible to getting something in service. We had another case recently where a veteran had a history of childhood asthma. They played sports in high school. It was cleared up, deployed to Vietnam. Between the stressors of everything that was happening in Vietnam and exposures to chemicals and humidity and whatever else they were exposed to in Vietnam, they developed severe asthma and had to be medevaced out. VA tried to say, well, you had asthma before. This is just a flare-up of a pre-existing condition. And so we got in and we were showing what's the difference between a real pre-existing condition, something that was noted on the entrance exam that was that hadn't resolved, and was it just a continuation of something that happened prior to service, or was it a separate incident? Just because you had something earlier, it cleared up, now you're fit for service, something similar happens again. This was a new incident, and so we were able to get the person service connected for asthma, even though they had a history of childhood asthma, because they didn't have asthma as a current condition at the time that they entered service. Now, this is why we put the disclaimer on these episodes as informational, not legal advice, because every person's situation is a little bit different and a little bit more nuanced. So just because we were able to win for that person, if somebody else comes in with a similar situation, the facts may be slightly different, and it may be that person did have a pre-existing, or VA is able to rebut the presumption of soundness to show that their future flare-up of asthma was really just a continuation of a condition that they had prior to service. But in this one situation, it was really, they had the asthma, it cleared up. They were later exposed to conditions in service that triggered asthma, and that was a service-connected condition. So the presumption of soundness is a really strong protection for veterans, even if you're coming in with some traumas or some prior exposures. You know that you aren't 100% healthy when you enter. Everybody comes in, they've got some stuff. I mean, you should be kind of peak of fitness around 18, but everyone had some, broke a bone in high school or had something going on. But that presumption of soundness is really strong because it's saying that when the military took you, they had their chance to inspect the goods. They did their physical exam. They looked you up and down and said, no, you're fit for service. We're going to expose you to these things. We're going to deploy you. We're going to put you in simulated combat. We're going to put you in real combat. We're going to have you do all these running exercises, all of this stuff. And if they were wrong about you being fit for service, it kind of falls on them, unless they can prove with clear and unmistakable evidence that something predated service, that you had a pre-existing condition. So what evidence matters most? The entrance exam is really, really key. When we get into a file, that's one of, if VA is denying something because they said it was pre-existing, getting in and looking at that entrance exam is really key for us. That's why it's so important that we get access to your claim file. There's different ways you guys can request a copy of your claim file or a copy of your military records with a Privacy Act request online on va.gov through the archives. But knowing what's in your entrance exam is really important to see what they actually noted. And sometimes you have to kind of read it really closely because the doctor's handwriting is not always super clear. There's the check boxes of something yes or no, and then they put the notes section. They'll put if you have scars, they'll put if you have flat feet. And flat feet is one we'll talk more about in the episode when we talk about aggravation, because that's one that we see a lot of exceptions for, where people get into the military with flat feet that are asymptomatic and then they become symptomatic down the line. So the bottom line is that the presumption of soundness shifts who carries the burden. So typically when you're filing a claim for VA disability benefits, you as the veteran have the burden to show that you served, that something happened in service. You've got to develop the buddy letters. You've got to, if it's in your medical records in service, you've already kind of met that burden. But you've got to show that you have a current diagnosis. You've got to give VA evidence, answer their questions, show up to their exams. You have the burden to show that something happened during service and that your current condition is connected to it. That's the burden of the veteran, and your burden is at least as likely as not, typically, unless you have a condition that meets another presumptive, if you were exposed to burn pits and you develop certain cancers, that's presumptively linked to exposure to the burn pits. So you as the veteran have the burden. The presumption here for presumption of soundness, it shifts the burden. The burden is on VA to show, if they want to say that something predated service, they have to come up with evidence. It's not only at least as likely as not, they have to come up with clear and unmistakable evidence that your condition pre-existed service, that it was present at the time that you entered service, to rebut that presumption of soundness. That's a high burden. So if you're getting denials because VA is saying, oh, well, this probably more than likely it existed before service, it's less likely as not that it started during service because it's more likely that it began during service. More likely that it began during service is not clear and unmistakable evidence that it began during service. So VA has that burden, and it's a high burden for them to prove. And so if they're getting that wrong, you want to file appeal, you want to get with a legal expert or somebody who understands VA law, an accredited claims agent, an accredited attorney who can help look at your file and hold VA's feet to the fire and make them apply their laws correctly about the presumption of soundness. So it's a really huge protection, and it's one that I think is misunderstood. It's definitely misunderstood by a lot of the medical experts that are medical professionals that are writing the CMP exams. It's misunderstood by some of the rating officers because they're so used to applying the at least as likely as not. If they kind of think they can just go in the opposite direction, say, well, it's less likely as not because I think it probably started before service. Not enough. And those laws are put in place to protect veterans and make sure that you guys are getting the benefits that you deserve and that they're not just arbitrarily being turned down without evidence that something clearly predated service. So the key takeaways that I want you guys to walk away from here is every claim involving a possible pre-existing condition begins with the entrance examination. So that's really key, to look at the entrance examination, see what was actually noted on it, what boxes were checked, what was handwritten in the notes section. Noted, to say it was noted on the entrance exam has a specific legal meaning. It must be recorded on the entrance exam. It can't just be mention of a prior history or record that the veteran had said that they had treatment for something previously, the entrance examiner has to have noted that they've observed it at the time of exam. If the presumption of soundness applies, VA bears the burden of rebutting it with clear and unmistakable evidence. So that's the part I was talking about earlier, that it's on VA and it's a high burden for them to meet. VA generally must establish both that the condition preexisted service and that it was not aggravated during service. And we'll talk more about aggravation in the next episode. And understanding who has the burden of proof can change how you evaluate a denial that you get if VA says that something preexisted service. It's going to help you understand your options for appealing it. So now that we've gone over the presumption of soundness, I'm sure I've left room for plenty of questions. Please pop them in the comment section. We love hearing from you guys. It helps us make sure that the content we're putting out is relevant to you and answering your questions and helping you advance your claims. But now that we've gone over the presumption of soundness, we are going to talk about the presumption of aggravation. Now that we've gone over the presumption of soundness, we're going to talk about the presumption of aggravation in the next episode. So stay tuned, and thanks for tuning in.